is also leaving the Colorado Water Conservation Board. I believe that's happening Friday. And then kind of going on to more big picture policy issues, starting at kind of the federal level. President Trump released a blueprint of his budget 10 days ago or so. And so DNR has been looking at how that would impact any of our agencies or divisions. There's a fair amount of uncertainty. It's a $1.1 trillion budget. It's looking at a 12% reduction at the Department of Interior, which is one of the agencies we partner with frequently. So we could see some outfall from that. It also proposes a 31% cut to EPA, including the elimination of 3,200 jobs. It's a 1/5 reduction. So that's a significant change in EPA, or at least anticipated change. As that would relate to specific DNR programs, the Department of Water Resources gets $220,000 annually from the FEMA National Dam Safety Program. It's used to support programs related to minimizing consequences of dam failures. And the blueprint says right now that this source of funding will be eliminated or reduced. So we're not sure what those impacts would be, but we anticipate some. Additionally, and I would certainly welcome Ginny or Tony's comments on this, DRMS gets non-discretionary funding from the Department of Interior Office of Surface Mining to do abandoned mine land work. The blueprint says that duplicative programs in this area will be eliminated, meaning that where discretionary grants overlap with mandatory grants, there could be some cuts. That may impact our program, and again, I'd welcome comments from Ginny or Tony on that particular issue.
Mr. Chair? If I may, yes, indeed, the division did look into the president's blueprint and assessed what impact it would have on DRMS. It will not have an impact on our minerals program. It will not have an impact on our coal program. And it will have a very de minimis impact on our abandoned mine lands program. It does take a run at AML funds, but those are only discretionary funds. Our AML funds are non-discretionary per statute. And therefore, the only way we could be affected is if, for example, BLM had some discretionary funds and they lost it. And so they lost a project that they would have otherwise included us in on and paid us for. But very indirect and very speculative.
That's great, I think. Last, COGCC, or the Colorado Oil and Gas Conservation Commission, gets about $100,000 annually from EPA to implement its underground injection control well program. There may be a reduction to categorical grants, which is what this is. Again, COGCC is unclear of what impact this may have on the program. There are several areas proposed to increase oil and gas leasing on federal lands, which could impact the role of Parks and Wildlife, COGCC, and impact their workload as federal leasing increases. Moving on to kind of the regulatory actions at the federal level, Trump has issued an executive order that would end the waters of the U.S. rule. It doesn't revoke the Clean Water Act, which is important. And so we will continue to protect our wetlands and streams, but and ensuring that water quality standards are met and locally driven watershed programs, management plans called for in the Colorado Water Plan will be developed and implemented. So I don't know that that will have a big impact, but it is certainly something that's at the forefront of many folks in the water world's minds. Additionally, and again, I would defer to Ginny and Tony on this, the stream protection rule revoked by the Congressional Review Act. We didn't think it was a good fit for Colorado, so it doesn't seem to be a terrible outcome for us, but it is a significant change, especially for the the eastern edge and the coal mining industry in the Virginia, West Virginia area. So moving, I think, into kind of the state legislation and what's going on, COGCC has an orphan well bill moving that I think is trying to deal with some of the issues that this board faces pretty frequently in terms of the abandoned mine program. Again, COGCC also, there's been noise around making a filing a statutory pooling bill that would affect how mineral rights can be pooled as it relates to oil and gas development. And again, in the oil and gas world, House Bill 1256 proposes setbacks from school property lines, which would have an impact certainly on how COGCC does business. And I'm happy to answer more specific questions about those particular items, but I think that making kind of brief remarks on them makes more sense here than it did at the COGCC. Lastly, Boulder County is in a lawsuit with the Office of the Attorney General, and that continues to move forward. Boulder County is also considering and reviewing proposed regulations that it could implement that would potentially lift the moratorium. COGCC made comments about those rules recently on March 14th, and they continue. I think they're up to be voted upon on the 23rd, but that could be continued depending on Boulder County's actions. And I think lastly, there will be a couple more shooting complexes opening, and I think, Jenny, do you know more about that? Nope. So on a former Excel power plant site, an additional shooting range has been proposed that will be opening soon and seems to be a very good outcome. CPW working with Excel. So with that, I think that's a pretty robust update from the Executive Director's Office, and I'm happy to take questions.
Do you have any idea what the timeline is on Dick Wolf's replacement?
The note that I have here says, I think the opening, they're looking through 3/31, or he's here through 3/31. And then the idea would be to get somebody in place kind of as quickly as possible.
So there could be a time when he's not here.
I think that's always a possibility, yes.
Other questions? Thank you. Next item, consent agenda. Do we have any? Okay. Item number 5, formal public hearing. Parkerson Construction Company, file number M-2016-050. Would all those who wish to testify in this case please stand? You promise to tell the truth? Thank you. I think the first item for the board is we have a draft hearing order that you've been given that wasn't included in our packet, but it's been distributed this morning. If you want to take a few minutes and look that over, we need to decide whether we're going to accept that or not. As part of that, as I understand it, we've agreed to allow the objectors to testify by telephone.
That's correct. Just for the record, the objectors submitted a written request to appear by telephone. Board chair has delegated authority to approve that and has so granted. Is she on the phone? Does anybody know? Look at Cammie's empty chair. Is there anybody on the telephone line?
I heard the dial tone earlier.
I did too, yeah.
I think Cammie's done double check with downstairs for us.
Okay.
Any thought on the proposed order, draft order? Okay.
Stephanie, have we heard back from the objector? We haven't heard back. We did
I talked to her
contact
last
them.
week and she said she still planned on it, and then I called her on Monday to verify that she had all the instructions from Candy to call in, and she had never called me back. So, and I gave her my cell phone. We did email her the presentation form and her presentation. She had it on the note. I don't know if she's emailed us back or not. She emailed back and she got the presentation.
No, I have not heard anything.
We need to accept the hearing order by motion.
Yes.
I move that we accept the draft pre-hearing order.
Second.
Any discussion? All in favor? Aye.
Aye.
Opposed? Okay. We'll follow the procedure in the order. I think we'll go ahead. I would think that the objector has the responsibility to be here.
Well, I think so too, and maybe Jeff or Scott can speak to that, but if you're not at the pre-hearing conference or you're not at the hearing, I believe it's party status. And that would be the end of it, but I'll let Jeff address it.
Jeff, you're here on behalf of the division. I'm not sure if the board wants to take any time to make sure that we won't have these parties on the phone. But pursuant to Rule 2.8.1, if a party fails to appear for the hearing, they lose party status. This hearing is set because of their objection. And so if they're not here, they can't carry the burden. So the board has the option of either having the division run through just a quick summary of the application and seeking approval, or the board could just delegate or allow the division to make.
Somebody's on the phone.
Do they?
Voice.
Okay.
Hello?
Hi.
Hi, yeah, this is Elaine Wooster. I've been trying to call in for 15 minutes, and I was getting a message saying that a call to this extension could not be completed. And then I tried the cell phone, and all I got was a voicemail, and I tried extensions 8185 and 8136 and got voicemails. And so then I thought, well, I'll try one more time, and this time I got through.
I'm glad you got through.
Okay.
All right, guys.
Yes, Ms. Worcester, this is Tom Brubaker, Chair of the Board. We'd ask that you assure us that you'll tell the truth today in today's hearing.
Are you speaking to me?
Yes.
Yes, I will tell the truth in today's hearing.
Okay, thank you. We're just beginning the process. The board do you have a copy of the draft pre-hearing order?
I'm not sure. I just found something on the email. It was a PowerPoint presentation and a connection to YouTube. And so that's all I have.
Well, we
And then
have,
whatever they mailed, the notice that I was mailed that gives me the outline of today's meeting. Yes, I did receive that.
okay. The board has adopted that pre-hearing order, which has the procedure in it. We're just at the point now to begin the process. If you look under C, it's the first item is the presentation by the division. So we'll give them 15 minutes. Then the applicant will have 15 minutes, and then you'll have 15 minutes to respond.
Okay, thank you.
Okay. Division, I guess the pre-hearing order says an introduction by the division. I'm not sure how that's different than the presentation.
Oh, yeah.
Really hard to get to it.
Yeah.
one for Bob or for me? I'm Stephanie Mitchell with the division. Do I need to put this closer to me? And today, sorry. And today we're here for the consideration of a 112C application with objections. The operator is Parkerson Construction Incorporated. And this is for the C Road Pit permit number M 2016-050. This way I'm just going to run over the staff overview of the application. So this is a 112C. It is permitted area is 84.9 acres with affected lands being 75 acres. This is a typical conventional excavation with on-site processing of crushing, screening, and washing. It's a phased mine plan in 40-acre increments with contemporaneous reclamation. The post-mining land use is cropland, and the proposed bond for this is $241,201. We received one timely letter of objection from one party.
Excuse me, Ms. Worcester, can you hear okay?
I can hear very slightly. I'm hearing mostly shuffling of papers.
Okay,
Okay.
we'll try and keep that to a minimum.
Thank you.
This is the kind of a location map. I'll point with my mouse here on this screen, but this is the city of Grand Junction. And the site is about 4 miles southeast of Grand Junction where the yellow pin is. And then here is a bigger map. The permit boundary is outlined in red. And I'm just going to point out a couple things here on the map with this mouse, unless we have a red pointer. Mr. Parkinson's house is right here. The 31 Road Pit, which is a permitted site, is here. This last summer in 2016, the division released 26.3 acres of cropland. And then again, this is the 31 or the C Road Pit permit boundary. This road going north-south is 31 Road, and this road going east-west is C Road. Just also want to point out riparian areas near the river are in this area down over here next to the river. Also, I'm just going to move on to this next slide to give you a better idea of like a general geographic cross-section. The site is on a mesa, Orchard Mesa, and the mesa is about 70 to 90 feet above the valley floor. And so the riparian area is down here by the Colorado River. And the site from the edge of the mesa in is another 1,700 feet or so. These are just a few pictures of the current site conditions. The notice was posted at the intersection of the proposed mine site entrance of the 31 Road and C Road. This is their notice sign. This is a view looking northwest. Right now it's currently cropland. And this is a view looking west. And that's all I have, just for kind of an overview of the application and the site, so you get an idea.
Well, going back to your one with the pit boundaries, the slide with the pit boundaries.
Sure. Oops. Wrong way.
Whose house did you point out?
Oh, I'm sorry. Alan Parkinson. This
Okay.
is Alan's house right here.
Okay.
I just said Alan.
You said that.
Mr. Parkinson's house.
Yeah, that's what you said.
That's the applicant.
Could you tell me where the objector's house is?
The objector's house is, so the mine entrance is right here. The objector's house is, I believe, 3/4 of a mile down 31 Road, south of the site.
So it'd be off the picture.
It is.
It's less than half a mile.
Oh, okay. I thought it was about 3/4 of a mile, but.
Thank you.
Stephanie, I have questions too.
Sure.
In your general geologic cross-section, you noted that the 25 to 35 feet is the depth of the construction material deposits. Am I interpreting that correctly?
Mhm.
So after excavation, and removal of the material, there'll still be somewhere in the vicinity of 40 or 50 feet above the Colorado River at the pit level, bottom of the pit. Is that your understanding?
Mhm.
Am I thinking about?
But just keep in mind too, that the pit is about 1,700 feet from the edge of the mesa in. So I guess I could.
And then also, there was some discussion by Colorado Division of Parks and Wildlife about yellow-billed cuckoo habitat. Could you point out on a map somewhere where that habitat is located?
Sure, and there's another part of this presentation I'm going to be doing to go into further detail about that, but I don't have a map on that presentation, so I'm happy to point that out right now. The habitat for the yellow-billed cuckoo is in riparian areas next to streams and rivers, typically in a heavily wooded area. So down here on the river, there's a potential that yellow-billed cuckoo could be living in this area along the river. And then just keep in mind that we're up on a mesa up here, like the edge of the mesa, is in here. If that makes sense.
Okay.
Anyone
Now,
have any other
you want to
questions?
start your presentation?
I think we're moving, isn't there an order to this?
Yeah, I made a mistake. It said you were doing your presentation. You weren't. You were doing what the order calls an introduction. So now you
That's-
could do your presentation.
Okay. Move along. Okay,
Sorry about the confusion.
that's okay. Okay. Okay, so this is my staff presentation here. The objector had several issues brought forth, but 3 of them were non-jurisdictional issues. One was the concern for a devaluation of nearby property, concerns regarding hours of operation, noise pollution, site pollution, and quality of life. The second was concerns regarding traffic and traffic safety, concerns regarding road impacts to 31 Road and C Road. And the third was concerns regarding the concentration of mining operations and the cumulative impacts of multiple mine operations
located in close proximity to one another. These were all addressed in the county commissioners meeting, which was approved last week. Their conditional use permit with the Mesa County. I think they started with 17 stipulations and they ended up with 20. And the additional 3, one was limited truck traffic to 300 trucks a day. And the other was they're not going to be including the asphalt plant and concrete batch plant. And I forgot what the third one was. Okay. So the jurisdictional issue that we outlined in the objector's letter was concerns regarding potential impacts on wildlife, specifically a concrete and asphalt plant that would potentially diminish wildlife habitat. So this issue correlates with the division's rationale document dated February 24th, 2017, which I believe you have a copy of. Within the permitting process, the division sent a notice on November 18th, 2016 of the application to Colorado Parks and Wildlife. We did not get a comment back with that original notice. But then with the adequacy reviews, which there was 2, that the division required more information from Colorado Parks and Wildlife, so we received 2 letters. One was in the first adequacy review, a letter from Colorado Parks and Wildlife, and then there was a second updated letter from them as well. The agency indicated that the proposed operation was not in conflict with any of the federal or state laws, and so the office determined the adequacy responses satisfied the requirements of Rule 3.18 and 6.4.8 regarding the protection of wildlife. In the permit application, the applicant did state that there may be a possibility of an asphalt plant and ready-mix batch plant. The asphalt plant and ready-mix batch plant were removed from the approved conditional use permit, as I mentioned before, with Mesa County. And so therefore, the plants are no longer a part of the consideration for this application. I will note also that Parkinson Construction committed to incorporating Colorado Parks and Wildlife recommendations, such as fencing, noxious weed mitigation, and a native seed mix to areas of disturbance to existing vegetation. The fencing would be to allow movement of wildlife. They have certain standards for that. Going into the yellow-billed cuckoo, I just want to make note that the proposed site is in close proximity to the proposed critical habitat for the yellow-billed cuckoo. The yellow-billed cuckoo is a federally designated threatened species, but based on an inspection by me and verified by the Colorado Parks and Wildlife, this site is not in a habitat for this it's not located in a habitat for this species. The proposed operation is outside of the designated boundary for habitat of the yellow-billed cuckoo. With that, the office has determined the application satisfied the requirements of section 34-32.5-115, parent 4, Colorado Revised Statute, and issued its recommendation to approve the 112C application over public objection as detailed in the office's recommendation and rationale document dated February 24th, 2017, and further detailed in this presentation. The office requests the board to approve the C Road Pit permit number M 2016-050 over objections. That concludes my presentation.
Questions? Okay, thank you.
You're welcome.
Mr. Chairman,
Oh,
Excuse me.
sorry, I'm a little slow.
okay.
So recognizing that the permit boundary is not actually in, there's no actual critical habitat within the permit boundaries. Do we have any sort of testimony or witnesses that can speak to how far from critical habitat disturbance might impact the threatened species that we have here, potentially? And do we have any credible evidence of have there been sightings of this species in the area and so forth?
I haven't heard any. I don't know.
Just going off of recollection of discussion, this is Russ Means for the division. Discussions and stuff in the local newspapers and regarding the potential listing. We want to make sure that it's understood that this isn't listed for habitat, it's potential listing. There may have been 1 or 2 sightings in the last 10 or 15 years. So that's why the U.S. Fish and Wildlife is reviewing whether this should be a part of habitat or not. Mesa County commissioners are not in favor of that listing because it's on the very fringes of the cuckoo habitat. So based on the information that we have readily available and relying on the Division of Wildlife's opinions and it's outside the habitat and set back far enough that it shouldn't have impacts in our reviews with CPAW and ourselves.
Kind of following up on the discussion of that issue, which seems to be like the one jurisdictional issue that we have here before us, is that the CPW's letter stated that their recommendation was that the applicant contact the Fish and Wildlife Service to determine whether the project would result in a take of the species. Has that occurred, and have there been, did Fish and Wildlife have any comment on?
They
that
did
issue?
not, and they were not contacted.
So the one recommendation.
Based on the fact
CPW
that the habitat for the yellow-billed cuckoo is down by the river and we're up on the mesa where it's just cropland. There's really no trees and they need wooded areas and a stream for their habitat.
What I'm trying to get at is how far from the critical habitat or proposed critical habitat would disturbance impact or result in a take of the species. So is there short of disturbing the actual riparian area, which would be considered habitat, is there typically with wildlife impacts, there's a setback or some distance at which a disturbance would be considered a problem or not. So I'm just trying to get to a little bit more specific information about that.
The permit boundary is, outside of that habitat. I think
Yeah, I
that's,
understand.
I don't know how to make that anymore.
It may, to clear up, there's like a 1,700-foot buffer between the edge of the bluff, the mesa, back to where the actual permitted area is, and then the affected lands are within that permitted area. So it's safe to say there's almost 1,800 to 2,000 feet. I'm just estimating there, and that a buffer, plus there's usually a visual berm that is put up along there. This isn't going to be daylighted out to there. There's actually a setback. It will never be into that river corridor at all. So there's no way for any material or anything else to impact those wetlands. There's no activities that are proposed within the mining operation itself that would affect any type of habitat there. There's also down on the river bottom, there's at least 4 or 5 permitted pits that are down on the river area in those areas. And there has been no indications of any kind of impacts to endangered fish or any of the things that are known there. The cuckoo is a potential. They're still evaluating it, so it can't be, we're trying to look at what a potential would be, whereas we're dealing with facts and stuff that the fish haven't been affected by the sites that are there, and or any of the other endangered species and stuff that are down along the corridor. This is outside the corridor, and there's no habitat within the permitted boundary that matches the habitat for the cuckoo.
And Stephanie, you mentioned that in the special use hearing at the county level, that the applicant agreed not to have a concrete or an asphalt batch plant operation at the site. Is
Yeah,
that-
the stipulation was that there was a 3 years from now, they can apply again for redo the whole process. And I'm not sure if the applicant is planning on doing that or not, but at that point, if it does get approved by the county, they would have to request a technical revision with us, and we would evaluate that at that time.
Okay.
Mr. Means, did I hear you say earlier that Fish and Wildlife had yet to come back with a comment on this?
They were, because of the comments and stuff that we received in conversations that we had with the Colorado Division of Wildlife, it was suggested that we may want to contact them to see if there might be some impacts and stuff to it down the road. Fish and Wildlife wasn't contacted because there's no habitat within the permitted boundaries. And in our estimations and in our review, we felt that there wasn't going to be any impacts and stuff to the river corridor. So it was just a burdensome extra step that wasn't necessary for this particular species.
More questions? Okay. Now the applicant. Yeah, 15.
Good morning. I'm Alan Parkerson, Vice President of Parkerson Construction, Grand Junction, Colorado. Just a quick introduction. Our company was formed in 1951 as a sole proprietorship by my dad. He retired in 1982. At that time, my brother and I incorporated a business into Parkerson Construction Incorporated and began our operation. Back then, it was mostly all just excavation. In 1985, we started with our first permit that we received from the state on a 110 permit. Since that time, we've acquired 9 permits, and this would be the 10th one. During those 9 permits, one of them has been fully released. 8 of those are in Mesa County, one of them's in Rio Blanco County. And that's the area we service as a company. All those permits have been kept in good standing with the board and with the division. We do believe that this application for file number M 2016-050 does meet all the requirements set forth in the act and the rules. In particular, that adequacy demonstrates that all disturbances and activities will minimize any potential impact to wildlife in that area. We've had several conversations with Bob Morris, who is the district wildlife manager there in Palisade, and this has been about this project. His first response was no response at all when we sent out the request for comment. He didn't comment because his response was he didn't think it was a big enough impact to even respond. Because of the prompting by the board on the adequacy letters, he wrote 2 different letters. One of them referenced the cuckoo bird and different things we could do, such as the fencing, seeding the slopes with native grasses, and things like that. And we've incorporated all that into the application so that those recommendations are included. The cuckoo bird, like we say, and we've heard that discussion quite a bit, that it's not a threatened species yet. It's a potential that could be, maybe not. We do set back away from the river a minimum of 1,700 feet. And that's where the habitat would be. So we have at our closest point a 1,700-foot buffer that's already been mined out. That would be across the pit to the northeast where the current pit is. So that section that potentially could have been mined out and caused a disturbance has already been done over the last 30 years. And obviously no disturbance has happened. The kookaburra, like we said, has only been sighted in Mesa or Delta County once or twice in the last 15 years. The district wildlife manager, Bob Morris, has concluded in his letters that this development will have no long-term impacts to wildlife. He recognizes that during times of disturbance, the local populations of animals will move away, but as soon as we're reclaimed, they will return. As you can see on the letter or the picture that Stephanie had up earlier, I live right in the pit. That's a reclaimed part of the pit. So that portion was mined out about 20 years ago. The field directly east of my house, 26 acres, is all in cropland today. Part of it's in hayfield. Last of it was in beans last year. I don't know what they'll plant this year. But we return it to the same thing it was before we started, which is cropland. The side slopes, 3-to-1 slopes, on the back slope is finished with native grasses. So that was one of the items that the wildlife asked for in their recommendations. Nothing new is going to be added to that neighborhood. We've currently been mining there ourselves for over 30 years. The area has been mined for over 50 years because that's where the gravel deposits are, right in that terrace. So, as you heard earlier, we had applied to set a concrete plant and a batch plant asphalt hot plant in this location. Through the county conditional use process, we've decided not to do that. We have the option of being able to go back in the future, but at this time we don't have any intention of going back. That pit, as you saw in the little description, is located on a terrace about 90 feet above the river. It also sets back above the river. We have a field in the bottom that's about 25 acres. It's a agricultural field, but it's a buffer between the toe of the hill that goes up to the Bluffville mine. And then when you get to the top of that hill, it's still another 1,700 feet back to where we start mining. It's kind of inconceivable to me that we have any impacts on anything down in that river bottom because it's already, reclaimed and finished. All these activities will be contained within a berm at all times. Even during mining, we keep a berm up, so all of our storm water is contained on site. Nothing leaves the site. This is the way it's been done in the existing pit. And when it rains, we have containment areas that it just soaks into the gravel. That gravel accepts water really fast, usually within 24 hours. It's migrated down through the gravel into the groundwater. The pit we're mining now has no really obvious water other than rainwater because it's a dry pit. There's no water exiting the site at any time. So we believe there is no effect on the Colorado River whatsoever. And then currently, right now, that entire area that is to be mined is cropland. And at this point in time, it's completely plowed and disked, and there is no vegetation on it at all, as you kind of saw in some of those pictures. It's plowed cropland, ready to be planted. It's a seasonal crop that every year it changes. And as it changes, every year they disc it up, they plow it up, and there is no habitat of any kind for any animals. It's just bare ground. So in conclusion, we really do believe that this application has met all of the requirements of the board and the act. Any questions for me, please?
Questions? Nope.
Thank you.
Now, Ms. Worcester, you have 15 minutes to make your presentation.
Okay. In response to some of the things that have been mentioned, my house is a little bit less than a half a mile from the proposed pit. And, in response to what the county commissioners decided last week, we're not real satisfied with what they decided, but we have to live with it. We would still like to see a little bit more compromise in terms of hours of operation and amount of total trucks that are going to be allowed to come in and out of that pit every day. And as far as the asphalt and cement plants go, I did think it was 3 years before they could apply again. However, the condition states they can apply for it in the future, which could be as early as next week. I do have a call into the commissioners to get this clarified. You know, I thought it was going to state that they could not reapply for that for 3 years. Also, I mean, yeah, then, let me see. Okay, so as far as my concern about the wildlife, up here in Orchard Mesa, directly west of where the proposed pit area is the Orchard Mesa Wildlife Reserve. And that is closed from March 15th through July 31st for wildlife habitat preservation. Also, just north of the proposed pit area on the north side of the Colorado River is the Colorado River Wildlife Area. That's closed all year in an effort to preserve the wildlife habitat. My husband and I have lived here for 23 years. And we walk down along the area where the proposed pit is about 3 or 4 days a week, all year long, during all 4 seasons of the year. We've seen deer, we've seen fox, we've seen coyote, we've seen bobcats, we've seen badgers, turkeys, geese, ducks, gold eagles, bald eagles, owls, peregrine falcons, sandhill cranes, blue herons, okay? Now, there were, the few trees that are in the area are loaded with bird nests. Okay. There is one little small area that the applicant has already torn down the trees. I'm assuming that that is to access the right-of-way that he applied for and received from the county. But, you know, that's part of their habitat that has been destroyed. And then most of the area, as he said, consists of open fields that are used for agricultural purposes. And then there's 4 species of endangered fish that inhabit the Colorado River along the 15-mile reach from Cameo to the Utah line. Okay, we've also been hunters in Colorado for more than 30 years, and we can tell you from our own experiences, the slightest bit of noise is going to spook any bird or animal, and it's going to cause them to retreat from the area. So I really can't believe that the noise made from a gravel pit is not going to spook the animals out of the area. And then no environmental impact study has been conducted for this project. And, you know, we really thought this should be a necessary part of the process. And you know what? We have lived with the current gravel pit here for 29 years. We don't love it, but we have learned to live with it. And we're not opposed to the gravel mining. We are opposed to the asphalt plant and the cement plants being erected in an area that is zoned residential and agriculture. And that's been taken out for now. You know, it could come back at a later time. We're just asking for some compromise. You know, we understand that gravel is a necessary resource for the county as well as the state. And that's all I have to say. Thank you.
Thank you. Questions? Guess there's no questions from the board. Does the operator or the staff have any questions? Now, Ms. Worcester, you have the opportunity to make a closing statement.
I mean, I wish the Parkersons well in their endeavor. You know, they've always been good neighbors. This is nothing personal, you know, but this is our home too. And, you know, to have this kind of traffic on a daily basis and this kind of noise really, you know, makes a negative impact on our quality of life here. And so basically, we're just looking for a little bit of compromise that we can all live with happily ever after. That's all I have to say.
Thank you. The division, do you have a rebuttal statement?
Stand.
Go ahead and sit down.
We just want to make a couple of quick clarifications and based on some comments, and then we'll call it good. Again, some of the impacts and stuff that the objector notes and stuff are from the asphalt plant. We'll let the applicant address those, but clearly the county in their conditional use permit eliminated that. If they were to go back in front of the county to do that process, and it's their process, so I don't know whether it's a week or 3 years, but Mr. Parkerson is under the impression that it's 3 years, and so are we. That would require a technical revision, so they would have to come back before us and have a thorough review at that time as to the impacts, of that facility in the area. So even though it's not part of it now, if in the future it does become part of it, it has to go through the process again where the division would have to do some review. So that's an important aspect for the board to remember. The other thing is that Parks and Wildlife, we rely on them as our experts. They are a sister agency, and the fact that they didn't have a comment at first, but after we got objections, they sent us 2 letters, and that the applicant addressed those, and that to meet the requirements of the act and the rules is very important. Going above and beyond that, Mr. Parkerson will talk a little bit about the possibility of going ahead and talking to U.S. Fish and Wildlife. There's no habitat there, but we'll let him talk about that. Impacts to the wildlife due to the noise. There's already a pit there. On the picture and stuff that you saw, that the 31 road pit is right adjacent to Mr. Parkerson's house. It's kitty corner from where this site is in that. So there's already ongoing excavations and processing and everything at that site. So the impact from the wildlife has already been there. They've already adjusted to it. Being a hunter myself, I can tell you that they do move around, but they don't move away. And we have pictures and stuff of blue herons and stuff next to the stackers in rifles. So wildlife will adjust to it. This pit, the current pit's been there for a number of years, so they've already adjusted to noise and everything else. So the impacts have already been felt and adjusted to by the wildlife. And I don't think, is there anything else that we want to bring up? Okay. Is there any questions from the board, from us?
Is there going to be any more removal of trees with this pit?
We'll let Mr. Parkerson answer that, but yeah, he's indicating no. So, and I'm not too sure even what they're talking about. It may not even be within the permitted boundary, and stuff, and that I'm not too sure exactly what that reference was. That's the first time we've heard anything about that. So.
All the surrounding area, that's privately owned and handled by other residents, not by you, is that correct?
Well, we'll let Mr. Parkerson
Okay.
come up and
All
let
right.
him answer
Sorry.
that. Are you done with the staff? Okay, all right.
One quick question.
Yes, sir.
The reclamation land use, the part that's been released, I think is the green shaded area on the site.
26.3 acres, yes, sir.
Yeah. So what kinds of crops, is that just returned back to pasture grass, or are there other agronomic crops that are able to grow?
We'll let Ellen, Mr. Parkerson address that. I believe that actually some of the croplands and stuff there is used for with a local vegetable stand in that. So they rotate crops around, but I'll let him answer that. So. Okay.
Go ahead, Mr. Parkerson.
Alan Parkerson. To answer that question about the crops, it's currently about half of that 26 acres is in grass hay. The other part was in beans last year, but they rotate the crops. They use the alfalfa. They did alfalfa a couple of years ago to build the nitrogen. And generally when we're coming back with newly reclaimed land, they try to run alfalfa for a few years. And that does kind of green manure the soil where they till in as they make it. They improve the value of the land. And after that, then they start growing their row crops such as, tomatoes, peppers, beans, anything. But the land that we're using right now is done by a truck farmer who rotates his crop depending on the market.
I'll go back to the question that I had. The area surrounding the outlined area, that is not owned by you, but privately owned and farmed by somebody else. Is that correct?
Portions of it are owned by us and farmed by someone else, but the portion in the reclaimed area is owned by us. The field just to the east of it is owned by Dick Melgosa. It's farmed by the same farmer that farms ours. The portion to the south is owned by Pauline Howler. We have two farmers. One is Okagawa Farms, which is a truck farmer. The other is Bill DeVries Farms, which is another truck farmer. And Okagawa's do take care of the stuff to the south as a portion of ours also.
And the area within the red, are you going to be developing, or not developing, but working on that in its entirety all the time, or is this going to be phased?
It's phased in. We'll never touch more than 40 acres at any one time, but we start in just as we've done in the other. We just start to, as soon as we can start reclaiming, we reclaim behind us as tight as we can. All we need is just enough room for operations and stockpiles, and then we start trying to clean it up. The area that we're mining right now is bigger than we like, but because of the access point, we have to leave that access point and we can't really claim any further than we have until we get to the eastern boundary of the existing pit. Then we start at the east and reclaim back to the west.
So all that land still just stays open. It's plowed, but it doesn't, you don't use a no-till drill or anything on there to keep a ground cover on that so you don't lose that topsoil or it doesn't go into the Colorado.
Well, what the truck farmers generally can't do that. They generally have to turn it every year and plant new crops because most of their crops are raised in the greenhouse, taken out and placed in the ground. Just another few weeks from now, they'll be placing their tomatoes and their peppers, that kind of thing. So they have to have the ground pretty much sterile from all the weeds and everything to do that kind of operation.
But the area of land that you're not working on presently, it seems to be disturbed.
Well, yeah, it's being farmed.
Okay.
It will be farmed, and it will always be farmed in front of us. And as quickly as we can farm it behind us, we put it back into operation. So when we start, it's sorry about that. When we start, it's agriculture land. When we finish, it's agriculture land. It's just out of service for the time that we're actually doing our mining operations.
Any other questions from the board? Thank you.
Thank you.
We'll close testimony. What's your pleasure, board?
It would seem to me that the only issue that we have to address is wildlife impacts. And in my view, there are no significant wildlife impacts. I would approve the permit over objections.
I have some concerns about the potential wildlife impacts, but in the absence of any witnesses to give us more information or alert us to serious concerns, I don't think I don't know that I have a basis on which to deny the permit at this point. But I would, and I understand that Ms. Worcester is probably not in a position to be able to go out and hire consultants and so forth. So that part I understand. It's just that I would like to see a little bit more attention paid to wildlife issues. But in this case, I mean, I think the division's responses are adequate, and I don't I don't see a reason to deny a permit at this point.
I agree. I'm sympathetic to the objectors and the issues that they're raising, but looking at the issues within our jurisdiction, which is the wildlife issues, I don't think we've been shown that there has been impacts and that from the letters from CPW and testimony here, I think that we need to approve the permit over objections.
Have we had a second yet?
I haven't made a formal motion, but I will make a formal motion.
I just would say that, it appears to me that staff's done a very good job, and I understand the issues that the objector has, but, these are land use issues, and typically that's what happens, and unfortunately or unfortunately, that doesn't fit our purview, and I think the burden has been met by the petitioner, and I would support approval over objection. We just don't have land use authority.
I think the key wording on the wildlife issue is minimize. I think that it's pretty easy to see that there's a minimized effect to wildlife for this application.
I agree with, whatever's been said. I think the one thing, and I think speaking to the applicant, that if I understand right, there will not be any more destruction of trees and so forth. That will at least hold it at a static level than further destruction. And I think that I certainly would like to have seen more area that was viable for wildlife, but as it is, I think that I have no choice but to think that we should go ahead and approve it.
Okay, so I move that we approve the C Road Pit File Number M 2016-050 over objections.
Second.
Moved and seconded. Any more discussion? All in favor?
Aye.
Opposed? Motion carries. Let's take a quick 10 minutes. Be back on this clock at 20 after 10.
We're done. I can go, right?
Yes, you can hang up now, Ms. Sister.
Okay, thank you.
Thank you.
Thank you. I just think that it slows down everywhere. Preserve not only the topsoil, but this is something that's is slow and maybe such that garden crops, tomatoes, green peppers, and I don't know that much. They do the grasses and other things, but the competition is already so great. It's not the case. I don't have it. As I look at a lot of land, that's just blowing in the wind.
Mesa, I don't.
Yes.
And they got good water.
That'd be good.
Yeah.
they're serving. Yeah. Shocking. No, I'm not your that. The agency. No, I know. Sounds like well, that's for the.
Oh, really?
I know, well, all of us. Yeah. The overall meeting, we're on all meetings. Lots of heads. I'm so happy.
We did find a hearing company. I'm sorry? We did find a engineering.
What?
Up to the gum tree. Up to the gum tree.
Yeah.
No comments.
Right. I'd love to.
I was going to close out our, I didn't realize we were still up here.
Or is this John? No.
I'm just trying to problem solve. Just trying to problem solve.
This is.
What?
What we got here is a failure.
Yes.
She wants somebody to video
We're going to start with the division, and the applicant will have a chance to present their side of the motions, and then the objectors. So division, if you could provide us a quick introduction and what we're doing here today.
Thank you, Madam Chair. Scott Schultz on behalf of the division, the coal division. And in this case, the division is staff to the board. So there are 3 parties involved, 2 parties which have filed motions in this. I believe it's the Mr. Beckwith who represents Mr. Fontanari. It's filed the motion that is at issue today. I believe that it'd probably be prudent for him to go first as he carries the burden. There is a stipulation that was reached. I'm not sure if the board has that at hand. So Mr. Justice, who represents Snowcap Coal, also filed a motion regarding having the hearing today. If you look at number 5 of the stipulated motion, it is agreed upon that the full-blown hearing will not be heard today. I'm not going to get too much into Mr. Beckwith's motion, but in a sense, it requests that the TR 69, the consideration of that before the board, be heard by an administrative law judge. It's the division's position that there are rules directly on point that require this hearing to be held in front of the board and not ALJ. And specifically, it's section 2.08.4. Now, I'll just paraphrase a little bit. Is that in this case, the division has issued a proposed decision approving TR 69, which was proposed and submitted by Snowcap Coal. And in section 2.08.4.6, which is hearing and notice requirements, B, little b, and then triple I. It says, if properly requested under the provisions of the subsection, a hearing shall be held at the next regularly scheduled board meeting, and a final decision shall be made at the hearing and become immediately effective with notice of decision being mailed to the permittee. Before that, it also talks about the applicant or any person with an interest which is or may be adversely affected may request a hearing by the board. So it's the division's position that this hearing not be held in front of an ALJ, but instead be held in front of you as the rules require. After hearing from Mr. Beckwith and Mr. Justice on the ALJ issue, we would request permission from the board to set a pre-hearing conference. There's nothing specifically in the rules that requires or contemplates a pre-hearing conference, but I think given the nature of some of the issues in this TR, that it would be extremely beneficial to have a pre-hearing conference providing time, witnesses, exhibits. I think that would really help the board in the future as to when this is actually before the board.
So the decision that we're making today is whether it should go before an ALJ.
That's correct.
I'm still a little confused.
Yeah, that's the motion for Mr. Beckwith, and I think he has some other clarification questions in his motion, but I'll let him address that to the board. But
But if we decide that it shouldn't go before an ALJ, we wouldn't do the hearing today. Is that correct?
Correct, and that's part of the stipulation. That's number 5 in the stipulation. Right. And the other motion for Mr. Beckwith is to set a date in front of you. If you decide that is not to be held in front of an ALJ, but instead that you retain jurisdiction over this matter, that we do set a date before you. And again, as staff to the board, I think it would be extremely beneficial to have a pre-hearing conference before this comes back before you. So with that, I'll I'll hand it over to Mr. Beckwith. I don't know if we want to have any parameters on timing.
No, that's fine.
Thank you.
So Mr. Beckwith, if you could come please sit at the table. And I forgot to swear everyone in. So if you're going to be testifying today, can you please stand and raise your right hand? Do you swear to tell the truth?
Yes.
All right, please have a seat and identify yourself for the record.
Hi, my name's Jim Beckwith. I'm an attorney, registration number 2295, and I represent the objector, Rudy Fontanari Jr. I filed my motion, and I appreciate Scott giving a description, but he got it wrong. And let me explain why I filed the motion and why I'm here today, and why I'm also here without a coat and a tie, because most attorneys appear in a coat and a tie, and I do too. But I didn't know that this matter was coming up in front of you until 36 hours ago. I didn't even come down here to attend this meeting. I came down here to file something and only happened to walk in. I have not practiced before this board before. And therefore, the rule is you look up the rules and you figure out, you get notices from the board, and a proposed decision was rendered, and that was rendered on January 30th of 2017. On February 6th of 2017, I filed in typical fashion a rather comprehensive set of objections. And I also looked at your rules, and it said if you want a hearing, you got to make a request, and I did. If you want an ALJ, you make a request, and I did. Because when you tell an attorney he needs to make a request to cover things and he doesn't know exactly how everything is going, what do you think an attorney's going to do? He's going to ask for the moon, so he covers everything. Then I looked at your rule and I looked at your statute, 3433-116, dealing with a technical revision. And it says that it would be expeditiously scheduled and processed. I looked up and I found that there was not just one ALJ, there was not just one person before whom a hearing would be conducted, it would be multiple people. And so I thought, all right, if we go through a formal hearing, which under the statute would be 24-4-105, then there is a right to discovery, there's a right to subpoenas, and there's all these rights and everything else. And then you get a group of lawyers like me, and it takes forever, and it becomes cumbersome. And that did not appear to me to be expeditious. However, I could not find anything in the rule that would say to me that appearing before you, you would have already reviewed all of the written materials that have been filed in the matter, and that all you would be asking from me is, or from Mr. Justice, or from Mr. Stutz, or from Mr. Schultz, is legal argument, and then you would make your decision. Because your rule says that at the end of the hearing, you will make your decision. And that's pretty tough to do when you have multiple people, multiple notes, and you have to confer with each other whether you got your notes all the same, listening to witnesses. So I made an assumption that you would probably rely upon the written record, and we would appear here, we would give our oral arguments, you would have questions, we would respond to them, and then you would make your decision. But I've practiced 44 years, and I do not want to get embarrassed where I come here and I'm ready with all of that, and the first thing that is asked is, Mr. Beckwith, call your first witness. And I'm sitting here, well, they're not here. They're all over on the Western Slope. I don't want that, and I don't want that for Mr. Justice either. So I filed a motion for clarification, asking you to tell me what type and scope of review that you are going to be conducting relative to the hearing, so that I know whether to subpoena expert witnesses, whether I have to have exhibits ready to be introduced, etc. Or alternatively, if you were going to have a formal hearing, then let me know that too, so that I can do what I need to do as an attorney to be prepared in front of you. That is all my motion asks.
When you say formal hearing, what do you,
Well,
how is that different than what you just described as?
What I would call de novo review. De novo review is, regardless of whatever's been filed, it's day one, and bring in Mr. Stover as the applicant's consulting engineer, bring in Fugro Consulting, bring in Huddleston Berry Engineering and Testing, bring in Mr. Fontanari, and everybody gives direct and cross-examination. That is a formal hearing to me, and that's what I described, because that's what would be involved in 24-4-105. I don't think you wanted that, because your rules and your statutes say expeditious. Now, your rules also say that Expeditious means that the matter will come up at the next business meeting of this board. Well, if that were the case, we should have been here February 23rd, which would have been your next business meeting after I filed my objections on July 6th. Or it would have been today. But I could not find out from anybody. And yet I get all kinds of different information about what kind of hearing would be conducted. I will do whatever you direct me to do. It's much like your agenda. And I was teasing Mr. Roberts relative to the agenda. I'm an old-time dumb Denver lawyer. If the judge says we're going to have a hearing on your motion, then the docket says hearing on the motion, not the board's consideration of the motion. That's why I'm dressed this way and not as Mr. Roberts is dressed in a coat and tie. But I'm perfectly willing to argue it. So what I'm asking you, and last week John Justice and I discussed it, and neither one of us wanted to have the gamble of preparing incorrectly. All we're asking you for is clarification because your rule does not provide it. And when a rule says it'll be processed expeditiously, that's time. That word means time. That word does not say we will have an abbreviated type of hearing. That's why I felt it appropriate to file the request for clarification. And certainly, if you said there would be a formal hearing, is it Van Noord?
Yes.
Okay, Ms. Van Noord, if you said, well, we're going to have a formal hearing with all these attorneys, et cetera, well, then that becomes cumbersome and it's very difficult to handle.
The thing is we don't dictate exactly what the evidence that's going to come before us, how it's going to be presented. For example, we just had an objectors hearing in which they didn't have a lawyer, they didn't have witnesses, but they presented what they wanted to present. But we also, several months ago, had a 2-day hearing where we had lawyers, we had expert witnesses, we had evidence, we had
no doubt
cross-examination. So one of the ways that we get this all sorted out is through pre-hearing conferences, which is why Scott mentioned that, in which you identify your witnesses and things like that. So in a way, it's partly up to you. I mean,
and Ms. Van Noord, I don't doubt that. But your rule for your statute of 116 and your rule for 116 do not provide for informal conferences. I don't have a problem sitting down with Scott and Mr. Justice and the others and saying, all right, gentlemen, we have these exhibits. Do we have to bring in people? Can't we just stipulate to them? How do we simplify this process, et cetera? But your rule does not allow for that type of a conference. All I'm saying is, please tell me how you operate so that I can prepare correctly. I don't want to get embarrassed where one of you looks at me and says, Mr. Beckwith, you failed to bring in witnesses, because that's what I heard in the last hearing. You had an issue relative to wildlife and the effects of wildlife by a gravel pit. Well, you didn't hear from enough people. Perhaps you wanted to hear from more people. That's what I'm asking. Now, will you, at the hearing, have already reviewed the written record that we have filed?
I can provide you information on that. So
You can or cannot?
I can.
Good.
Okay. So we are provided the application. We are provided all the information related to it, all the objectors' information, all of their exhibits and everything to review prior to the hearing. It is de novo review. The division acts as staff to the board. They are not telling us exactly what to do. They're presenting us the information as they see it. And the board makes the decision based on the information that we've reviewed before the meeting and the information that we've heard during the meeting. And then we have an open conversation on the record in front of everybody, which can be very awkward, but we still do it, and make our decision and issue our findings at that time. And then John will write up the order and it will be the board's order.
You've just answered all of the questions that I had
Great.
in my motion. And it's the first time I've gotten the answer. I appreciate it very much.
Okay. Do you still, do we need to address the motion as to whether?
My motion doesn't request an ALJ.
Okay.
My objection did, but not my motion. But given how you have described it, I don't see a need for an ALJ.
Great. Are there any other issues before the board?
Not from me. I think Mr. Justice may want to come up and talk. Thank you very much.
Randy
Anybody
actually-
have questions of me?
Representative Fisher does.
You mentioned that our rules and statutes do not allow for informal conferences. That surprises me a little bit. What do you consider informal conferences? And in particular, I guess, through the hearing process, would you consider a pre-hearing conference an informal conference that's not covered under statute, or is
Mr.
that?
Fisher, what I meant was this. Your statutes and your rules provide different procedures for different types of applications or issues or pleadings that are brought before you. 3433-116 deals specifically with a technical revision, which is what we would be here on. The other statutes, 118 and others, deal with all other proceedings and in fact specify an informal conference. And since they specify that, then the phrase informal conference is a word of art. It means something specifically for that particular proceeding. And what John Justice and I had discussed was, I don't have a problem having a pre-hearing conference, but don't call it an informal conference because that's a word of art for a different type of proceeding. But I don't have a problem standing in the hallway, meeting, or anything else, because John and I had even talked about my just coming down here and meeting out in the hallway, saying, gentlemen, how do we want to organize this to make it the easiest way to present it to the board? So no, I am not saying that there should not be a pre-hearing conference, but I'm dealing with a very specific statute. I wish I were dealing with all the others, because then there's a whole bunch of other stuff that answers the questions. But that statute did not.
Thank you.
And before you go, I wanted to
Yes, ma'am.
talk about the pre-hearing conference, and which it's a more formalized process in which we have a pre-hearing officer that will meet with you and come up with a draft pre-hearing order where you discuss time, you identify your witnesses, and all those things. And one of the that really helps us move through the process is also helps you prepare for the. So it won't be just the three of you sitting there. There will be someone from the division, I believe, that will sit down with you and help figure that out. And that's one of their specialties in what they do. And it greatly helps everyone involved.
And I do not doubt that, but your rule for section 3433-116 does not say that.
Okay.
Nor does your statute say that. It says that for other types of proceedings. And that was my complication.
Okay.
Okay. Because I have practiced before the administrative agencies for over 30 years. This is the first time I've come here. And that's why I'd hoped to find a procedure. I don't have a problem with doing a pre-hearing conference. I think it's very beneficial, particularly in this situation, because I am very comprehensive in written materials. You may disagree with them, but I've tried to give you everything that I can give you. But it becomes unwieldy if you have to bring in all of the witnesses all over again for what I've already said in some of the written materials.
Okay.
Thank you.
Thank you.
Any other questions, Madam Chairman?
Nope.
Thank you very
Next
much.
time.
And again, I apologize for being so casual.
No worries. I'm not wearing a tie either. Mr. Justice?
Members of the board, Madam Chairman, John Justice, I represent Snowcap Coal, the permittee in this matter. I'll go ahead and seat. Also, I don't have a tie, so, but a couple things I'd like to at least raise on the pre-hearing conference concept. We need to accommodate, as I know that conference procedure is developed for other types of permit applications, and it's references other types of permit applications with longer timelines. However, we are now dealing with a 116 proceeding. It's required to be expedited. As Mr. Beckwith pointed out, under a strict application of the rules, that hearing should have either happened in February or be happening today. But in light of some of our confusion over what the procedural process was, parties stipulated, let's figure out what the hearing's supposed to look like. So when we approach the pre-hearing conference and procedural issues before the hearing, all of that needs to be taken in light of the expedited nature of a hearing on a technical revision. And so what I'm suggesting is things like discovery be extremely limited or at least not allowed. There's no right to discovery under 105, the Administrative Procedures Act. It is that the board may allow or the agency may allow or has the power for allowing the parties to conduct discovery and issue sanctions for failure. So under normal discovery deadlines, the next 30 days would not be enough for the parties to deal with that and also prepare for a hearing, an expedited hearing. So my suggestion is that when the parties get together, process or procedures which might be contemplated by the APA but are not required in every instance be set aside in order to allow the parties opportunity to fairly prepare for an expedited hearing, which we believe under the statute and rules should be required at the April meeting of the board. So,
Okay.
as far as the ALJ issue, it sounds like the objectors have at least conceded that it is appropriate for the hearing to be for the board rather than an ALJ. That's consistent with Snowcap Coal's position on this matter as well. Otherwise, I don't have anything further to address to the board.
Any questions, for Mr. Justice? And
Not being an attorney myself, I'm not aware of whether a pre-hearing, maybe this question is more directed towards staff or to the Attorney General's office, but is discovery a normal part of pre-hearing conference and hearings that would normally come before this board?
Mr. Schultz can answer that for us.
It's not a special on that division. It's not a typical process, and I think that if there was a need for discovery, that could happen at the pre-hearing conference issue or date. So it's not typical. I don't think that there's too many. I don't want to speak for any of the parties, but there's not any real hidden documents or major contentious documents. And again, if there were, that could be dealt with at the pre-hearing conference. I think there's a little difference as well, is that the statute and the rules don't disallow a pre-hearing conference. Instead, they just don't explicitly call for a pre-hearing conference in a technical revision. So there is other times in the coal regs that pre-hearing conferences are utilized, and that's what we would request to the board is to order a pre-hearing conference be held so that these issues could then be addressed.
Jim Stark for the division. I want to clarify one thing. We have an informal conference process, but there is no pre-hearing conference process in the coal rules. They're different than the mineral rules in that respect. So we don't have that provision where we have the conference officer, all the parties get together and you put those sideboards on like the orders that you get for minerals.
Yeah.
There's nothing that says we can't do that. If all the parties agree to do that, and again, I think they're brilliant. That's one spot where I think the coal rules are very lacking. But our rules mirror the federal rules since we have federal oversight from the Office of Surface Mining. Our rules are different. We have to basically do what the feds tell us to do as far as our rules go. But that doesn't mean it can't be allowed and it can't be, the board can't say, have a pre-hearing conference. That way we get those sideboards and we get the timings down. Otherwise, we could be here for a week. Nobody wants to be here for a week. So I think that it's a great idea as well. So I think it sounds like all the parties want that. Again, there's nothing explicit in our rules that say that. I think we would go with the minerals format for doing a pre-hearing conference. It works very well for them. So just a little bit of a difference.
Thank you for that clarification.
Madam Chair, just for the record, I'm Arbor decent cherry, losing a decent land and to me, it's rose by another name. We'd like to see the pre-hearing conference, whatever you call it.
Okay.
Sort of,
Do any?
my name on the record.
Okay, thank you. Do any of the parties have any objection to an informal conference that looks a lot like a pre-hearing conference under the mineral rules? Scott?
Well, my only objection is that we don't call it an informal conference, and instead we call it a pre-hearing conference where we have a pre-hearing conference officer. They provide their recommendations for the hearing to the board, and then the board can change it as they see fit. So I would prefer it not be called informal.
Okay, so we have a pre-hearing conference. Yes.
To dovetail on what Scott said, there is no provision for an informal conference on a technical revision.
Okay.
What we called it, it's semantics, I understand that, but semantics are important. If we call it an informal conference, it something outside of what the rules allow.
Yeah.
So pre-hearing conference or just a meeting to clarify the board hearing, we can call it anything you want.
Okay, as staff to the board, I appreciate you educating us on this side. We don't deal with the coal rules that often. We deal with the mineral rules, and that's where we're very comfortable. So I appreciate all the clarifications, and we will call it whatever needs to be called under the statute to make it legal and effective. So I guess the next thing I see is the timing of it. If we're I hear requests to be on the April board meeting. That is very fast, and that's an expedited schedule. I would, again, hear from the staff as to what that looks like, or
I think it would be a little tight for the division to fit in a pre-hearing conference for that.
okay, Mr. Justice?
The board's own rules contemplate this form of expedited proceeding. Snowcap coal is, in its ability to complete the technical revision actions, are being delayed. Some of these have to do with hydrologic communication to the underground mine workings. It's important that these revisions get done and completed. We recently had an issue where water was run onto this property and down to the area where we were concerned about hydrologic communications. We contacted our Division of Water Resources and had that resolved. However, it highlights the need that this needs to be done expeditiously. There's a reason why technical revisions are both expedited under the statute and the board's own rules contemplated it would be at the next board meeting. So we are advocating at least that it be at the April board meeting. Board has its discretion, and we appreciate that, but that at least Snowcap Coal's position on the scheduling of the hearing.
Do the objectors have statements on the timing?
Maybe excused.
Yes, please, sit down. So I may call you back up.
I like all of the comments that say you can't get it done by April, because I don't think you will be able to. What we propose, and I think Mr. Stutz would probably agree, if you're going to do a pre-hearing conference, assign somebody from the staff to conduct that pre-hearing conference, and we can coordinate with him or her the date where we meet and we go over all the materials. Whether all of us are available to get together like that, whether by phone or in person or otherwise, I can't tell you right now because we don't have everybody else's schedule. So if you would please appoint one person, maybe Mr. Stark for all we know, to conduct that pre-hearing conference. And Mr. Fisher, I told you, informal conference is a word of art. And now you're hearing from everybody else that it's a word of art. But the concept is fine. I have no problems with it. I don't think you can get it done, and I don't think all of us can get it done for the presentation at your next April board meeting. I think you're looking at May. Go ahead.
I would so agree.
Technical revisions are expedited because of their very definition. They are insignificant revisions that do not affect the general reclamation plan. We are so far out of the expeditious concept of your rule that not having it in April is not going to cause Snowcap Coal any problem, in my opinion, nor would it cause Di Fontanari. The issue of releasing water, we have very valuable water rights that are affected by problems with our land caused by Snowcap Coal's reclamation. No, I understand that, and I acknowledge that objection. Yes, we released water because we're testing our ditch because we're having to repair it.
Back with Amy, hold on.
Yep.
You got an objection?
Yeah, I think we understand your
Understood.
timing, and I understand that Mr. Justice brought up the water issue as it relates to timing, but
If he raised it, I have a right to respond to it. That's just fair.
I understand that, but I think we've heard enough at this point. I think we should.
Understood.
If there's anything else that we need to decide other than,
Having listened to all of us, Madam Chairman, now you understand my comment to Mr. Roberts before we sat down here. I feel like I'm in the film Cool Hand Luke, and our problem is a failure to communicate. We're all talking about the same concept, the same procedures, and we're using different words.
well, hopefully we'll get all on the same page today,
Hopefully.
and then you
That's
guys.
why I filed the motion.
Okay.
May I be excused, Madam Chair?
Yes.
Thank you.
I'd like to hear from the division to wrap up as staff to the board, and the board will deliberate.
Thank you, Madam Chair. Just some some more clarification on the pre-hearing conference that we're looking for is that we would request that the board require all parties to be present as they are in the other pre-hearing conferences held in the minerals program. Also, likely the pre-hearing conference officer would not be in the coal program. It would be someone outside the coal division.
And we have people on the western slope that can do that, I believe, or no? Or can travel to the western slope?
We have I think a lot of options for the pre-hearing conference officer, and I
We
think
won't say that.
No.
We
I
won't
don't-
decide that here.
I don't think we need to decide who it will be, but I can assure you it won't be someone in the coal division.
Okay.
And as far as the date goes, May is fine for the division, but it is up to the board on the language of the rule saying expeditiously held.
I agree. Just being a pre-hearing officer, doing a pre-hearing conference, preparing for that, and getting a pre-hearing order, you're talking a couple of weeks of time for that process alone. And we're, 5 weeks out from the April hearing, 4 weeks out. So I think that's tight in the pre-hearing conference.
Okay. Anything else to come before the board?
The last thing is, I guess, you can leave it up as far as the timing for the pre-hearing conference and location. I think we should be able to figure out those logistics. I don't think it's necessary to put those into your order.
Hearing nothing else, I will close testimony and the board will discuss.
Thank you.
Is there anything you wanted to add at this point?
Certainly. So there was some testimony about the coal rules, and the parties are right. There is no contemplation of a pre-hearing conference, but there's also not a prohibition. So it's not like they don't allow it, they don't disallow it, they just don't address it. So the board could, if it so chooses, order a pre-hearing conference to be held in this case. My recommendation would be that we're specific that the pre-hearing conference be held in compliance with Mineral Rule 2.7, which provides all the numbers of documents and who has to attend and all of that. We do have a list of pre-hearing conference officers who are not in the coal program and could be the pre-hearing conference officers for that. So the division and I are used to handling that process. So just as far as the pre-hearing conference request, that is a possibility. You could move to order that.
Okay. Anything else?
Do you want to deal with that, or do you want me to give you everything that I've got at once?
All at once.
Okay. Based on the statements from the parties, especially Mr. Beckwith, I think the board could consider the request for an ALJ to hear this as withdrawn. So we won't need to address that issue. It's not contemplated. That is actually not even allowed in your statute and rules. You don't have authority to delegate your hearing responsibilities to an administrative law judge. So that's not even in the realm of possibility for us. And just to clarify your ruling, Madam Chair, on the request for clarification, the board does handle this application and all applications that come for hearing on a de novo basis, which means we're not reviewing the division's recommendation. We are reviewing the application as if the application was made directly to the board, and anybody who wishes, any parties, applicants, objectors who wish to put on evidence and testimony from witnesses, the hearing is the time for them to make their case. That is all I have.
So we need to make a decision as to whether we are going to require a pre-hearing conference and the rules for that pre-hearing conference, and also set a time for this to be heard before the board. We've heard requests for it to be set at the April meeting as well as the May meeting. So what are your thoughts? Everyone's looking at Forrest.
I guess I can sympathize with Snowcap's desire to have it in April. But I think from a practical standpoint, I think May makes more sense, considering the amount of work that needs to be done to make that.
Is there a motion from the board on the pre-hearing conference and the timing of the hearing?
Take a stab at it,
Go for it.
and you can tell me if it's adequate or not. But I move that the board require that a pre-hearing conference under Mineral Rule 2.7 be convened, and that the subsequent hearing on technical revision 69 be brought back before the board on at our May meeting. I don't know what date that is, but is there anything else that needs to be included in the motion?
That's good.
Okay.
Is there a second?
Second.
Moved and seconded. Any discussion? All those in favor say aye.
Aye.
Opposed? All right, thank you. We will see you all back in May, and the division will be in contact with you about your pre-hearing.
I will not be here.
Sounds a little contentious.
Next up is discussion. I don't know where Tom went, so I'm just going to keep going. That's okay.
You'll just come back for lunch.
Next up is discussion of the 2017 rulemaking.
I'd like to talk.
Yeah, that's fine. I wasn't going to continue with that.
That's fine. I think let's let people disperse a little
Okay.
bit and we'll have that discussion.
We'll take a short break until Tom is found and returned.
Let's hope we can get him in an amount of time.
Do I? Do I have to be chair next? I was just chair before Tom was chair.
No, I think.
John's next.
Yeah, I think so. Yeah. Yeah, we kind of moved the list around to deal with transit mix. So that kind of threw off our rotation a little bit. I didn't think Mr. Singletary would be right on. I think he's okay. Yeah. No, I think Jill is vice chair right now. So we'll just go out of order and move Singletary up.
Okay, close enough.
I haven't seen John since last.
Is that right?
Crazy?
That is
I
crazy.
see him on Facebook, but
Yeah.
he moved to Grand Junction.
Just texted Tom on where he is. Yeah. Yeah, that's funny.
Funny.
How's work?
That's okay.
Yeah.
Yeah. I'm starting a whole new, get roped into doing MSHA stuff.
Oh, really?
Yeah, safety stuff.
Yeah.
So, it's interesting. It's not as complicated as your stuff. Which is
Are the babies?
good.
Yeah.
Yeah, they're crazy. They look crabby right now. So is my husband. He's sick, and so he's crabby, and he makes them crabby because he yells at them a lot, and they get sad, and there's lots of crying.
And you're like, you gotta go to work.
No, I'm like, see you later.
Have a great day.
Screw it up again, or I'm gonna get sued.
Absolutely getting sued.
Yep.
I don't think I screwed it up though. I didn't understand the whole differences.
Right, right.
I did not understand that to begin with, hearing complex differences.
There isn't a revision in the rule like this.
I'll just join you. Yeah, sounds good. Sounds good. Oh, it is. Well, plus, yeah.
So they hired the experts to go out there.
Yeah, exactly. She is. I went for going away to last week. She was missing a kilo.
So we're not the
Not in the same hurry.
So. We get started again.
No, I don't think it's good.
Next issue, discussion of possible rulemaking for hard rock and construction materials.
Thank you, Mr. Chair. I just wanted to broach the subject of some potential rulemaking coming up. We have in Hard Rock been looking at rulemaking to clarify the whole issue around custom mills. We've also been working with Department of Health, Hazardous Waste Management Division on this issue. And so I'm not completely clear on the history, but back in, I want to say 92 or prior to that is when Hazardous Waste Management was, the group was put together. And at that time, they were kind of gathering up what kind of activities they'd be covering. And one of the big things they do is landfills, but also waste management. And so I think the thinking was, well, there are these custom mills, which frankly, there aren't many around, but they develop waste, you know, in the form of tailings. And so there's been this kind of dual jurisdiction on it. Now, it got a little complicated because we started talking about custom mills and captive mills. So we regulate a lot of mills that are captive mills, meaning the owner and operator of the mine and the mill are the same entity. But it's really created a little slippery area for people to get into where there's not really any regulation of milling activities potentially. And so we have taken on that task, but our rules are not as clear as they probably need to be in that area. So we'd like to address that and get that cleaned up. There's also some other cleanup in the rules in general. As you go along, once, you just have to do some cleanup. Some of the rules talk about posting at 5 o'clock and, comment periods into 5 o'clock and these sorts of things. And with the advent of email and tweeting, that doesn't really make a lot of sense. So sort of de facto attorney practices are 11:59:59, I think, on the end of the public comment days. So there's a few things like that I think we could try and clean up. Also, as you remember from the Pueblo hearing that we had in December, the lady addressed the board at the end of the hearing, after the hearing was over, concerning signage and notifications at mine sites. And it is unclear in our rules. I think this is an area that's been kind of weak about what type of sign you should have at your permit, at your mining site, how big the sign should be when you're doing notification and that sort of stuff. So we could, I think, be a little more clear on that. We don't have to make it where you can read it from 5 miles away or whatever she was suggesting, but we certainly can make it where, I thought the sign today that was presented was a pretty good sign that looked pretty readable to me. Looked like if you're driving by, that'd catch your attention. You have to stop and read every one of these anyway. I mean, it's not like you can drive by and get the information, but you want to be able to sort of maybe catch a few words to see what's going on there. So that's another area that needs to be addressed. Is there's a couple places where I think the rules are out of line with the act. One particular one is with annual fees. In the act, it requires that the applicants or the permittee submit an annual fee report and map every year. And then in the rules, it says, well, if nothing's changed, you don't have to submit a map. And that creates a lot of problems for us. So I think I'd like, there's just a few little things like that we'd like to get cleaned up. I don't know what the board may be contemplating as we've gone through some of these hearings. If there's some rulemaking that you'd like to see conducted. On the Hard Rock side, the other area is we want to clean up a little bit on the prospecting. Losing contact with a lot of these prospectors, there's just a whole big bunch of hoops we have to jump through to terminate the NOIs, and we'd like to make that a little more expeditious if possible. I mean, we do our best to contact them, but it's really up to the applicants and the prospectors to keep their addresses and all their contact information updated with us. We do that through the annual reports. So it talks about terminating it, but it just doesn't quite finish the process. We'd like a little clarification there. Also, with respect to DMOs, there's kind of a separate release process with DMOs, and we need to have a more vigorous release process with DMOs. But we don't need two separate release processes in the same rules. We need to go back to the first release process and then add in there for DMOs, you have to do these extra steps. And what those extra steps are publication in a local newspaper in a 30-day comment period once they made application for that release. For regular releases, you don't have to do that. You just have to notify us via certified mail. You have to notify the county and you have to notify the landowner. And then we send out some notices to the county and the soil conservation districts. So, there's just a few little odds and ends that need to be cleaned up. I participate at the department level on a group that is charged with reviewing rules every year, and we review rules every year and talk about if we're going to have any rulemaking or what rules we've gotten rid of. The idea was to streamline where possible any rules. Maybe clarify would be a better word for me. I'm not sure we can eliminate a lot of rules. I think we can get rid of some of them, but I think more clarification perhaps. So I just wanted to open that up for some discussion. I've spoken offline with a couple of you at different times, and so I don't know if there's anywhere in the rules where you see where we might have the need for some clarification, improvement, addition, deletion. So the rule making is Jeff could speak to it a little bit, but we would meet with Stakeholder groups, that would be, probably have a couple meetings with that once we started that rulemaking. And then, there's a bunch of notification timeframes and that sort of thing. Maybe Jeff can address some of that.
Jeff Hewitt here. Yeah, just to follow up on what Tony was saying, it's been a number of years since this board entered into any form of rulemaking. And at that time, it was dealing with confidentiality related to prospecting notices and in situ leach mining and uranium mining DMOs. And so it was a very large rulemaking where we really, I think we touched all 7 of the important rules of the Hard Rock Act. And so it was very, very contentious, very time consuming. We convened, I think, 4 or 5 separate stakeholder meetings. I think the rulemaking was over the course of 2 or 3 board hearings. And I'm not sure that we're contemplating that kind of effort here. But as Tony indicated, there are some cleanups and clarifications that I think would be helpful, not just for staff in implementing and enforcing the act, but also for interested persons in engaging staff and engaging the board in the process. I know that both John and I have been kind of keeping notes in the margins of our regulations of things we'd like to clean up or change. And so that's kind of the request of Tony of the board is if you're finding spots in the rules that could use some clarification, let us know. It is the board's rulemaking, so we would defer and seek feedback from you all on how aggressively you want to approach the rulemaking. I think custom mill is likely one of the first spots that we could jump in and clean up and kind of get our feet wet on the rulemaking process, because it can be a time-consuming process. It involves drafting the proposed regulations, convening 1 or 2 stakeholder meetings at the least, just to kind of engage potentially impacted folks and see what their thoughts are, and publishing the notice of rulemaking and having the hearing itself. And so it can be time consuming, but I think there's a need for rulemaking in some of the rules. The other problematic area is, because we deal with both construction materials and Hard Rock Acts, I don't remember the last time we conducted a rulemaking on the Construction Materials Act. And so there are some inconsistencies between the 2 acts on process that leads to some confusion as well. And so that's, again, the question is, is rulemaking conducted on both acts simultaneously to the extent we can, or do we focus attention on just, kind of cherry pick some of the more important issues in, let's say, Hard Rock Act for construction mills? I think sign in some of those notices, we can do some simultaneous rulemaking across both acts. So really it's up to kind of what the board would like to do and that's what Tony and staff would prefer. But the rulemaking process itself, and if there's a need, I can coordinate with John and forward some relevant materials on just, some simple procedures and process on what it looks like, basic timelines and how long it would typically take for a non-controversial rulemaking process. So, is there anything else you want me to address?
No, I think that's it. I think it's just about initiating it and the notice, the comment periods and all that stuff we'll have to, that'd be the stuff you're talking about forwarding. And then the big part of it is reaching out to stakeholder groups. So getting the CMA and the CSSGA for 2 groups for sure. I know that would need to be involved with any rulemaking, and they can reach out to their members and also the environmental community and conservation groups. So you want to get everybody involved when you're doing one of these rulemakings. So the last one we actually did was for the 110.1 Hard Rock rules. It was very small, quick rulemaking. Although we did have a stakeholder group meeting that there were some people that were expressing a variety of concerns or comments. But I think it went when we got in front of the board. I think it was pretty smooth and easy. It really was very, very simple. We're just adding 110.1s back into the mix. And of course, we're talking about the rules. The act is the act, and we can't make rules that don't conform with the act. So rules are for clarifying, and that's it. So I would just welcome some feedback from the board. I I know, once in a while there's a comment that the rules are not clear here or, whatever. And so, that I think now is the time to think about that a little bit. And you represent a lot of the stakeholder groups. So I think we could get some meaningful feedback right here.
I have a question. Where does the board become involved in this? At the end, or does the division take on all of this and then bring something that they've coalesced to the board, or what?
Well, the board can request that rulemaking be done. So you could be upfront saying, we need rules to define whatever, and assign that to the staff and our attorneys. We would go and, this is one way it could happen. We could go back and work on whatever it was that you were concerned about. Since we work with the rules all the time, we're kind of more fully aware of where there are shortcomings. And so I think in this instance, what I want to do is just put this on notice today, have everybody have an opportunity to thumb through the rules a little bit more, perhaps, and come back if you have some issues somewhere, or if you can think about some recent hearings where something wasn't clear, you thought we needed more clarification, and we could talk about that. And then we'll have our list of items, which I've articulated a few of them today, that we'd like to present. And then at some point, probably sometime in the summer, I'm guessing, we might get started. We want to wait until after the legislative sessions in case somebody drops a bill and something comes up, because that would initiate the need for rulemaking if the act changed. But so we'll wait until after the session is over, which is just about another, just, I don't know, 50 days or something left, I think. There's not very much time left in it. It's around May 10th or something that it's over. So sometime in maybe June would be a good time to sort of provide more of a laundry list of what we're thinking about, maybe have a little more interaction, and then proceed. Once you give us the authorization to proceed, we would go ahead and start bringing that back before the board. And I don't know, then I think the process is we would redline the rules, bring it to the board, and then start get that okay a little bit, the preliminary okay, and then go out with the stakeholder meetings, and then come back for the final thing at some point.
Yeah, we've done it both ways. For the rulemaking that was triggered by the change in legislation, the staff took on the burden of drafting proposed regulations, convened stakeholder meetings, and then presented it all as a package to the board. For the 110.1, which I did forget, we did that just the last few years. We did it more of the way that Tony just described, is draft, obviously, or the initial draft will come from staff because we've got the resources to do that, but we could present it to the board for some preliminary discussions, some modifications, and then we'd kind of start the more formal stakeholder process. So we've got a variety of options, and I'll probably coordinate with John on what his rulemaking thoughts are. If Julie's still here, we might tap into her on her rulemaking expertise through Oil and Gas Commission, because they've kind of survived a few years worth of rulemakings. So we've got a variety of options, but I think the easiest way is to present preliminary drafts for the board for comment and further discussion.
Is it all right to mention one that I'm still troubled a little bit about now? Several months ago, I don't know, we had a hearing regarding an operation in Fremont County on the uranium activity. And I thought the staff did a great job, and we turned them over, but there was definitely confusion on what's mining and what's prospecting. And in my eyes, and I was new onto the, but I think that's one that, I didn't quite understand, because I thought environmentally staff did a great job of making, whatever they were going to do, less obtrusive to our environment. And so maybe and that's just one, maybe everybody else was clear on it, but I wasn't.
No, I think that was a confusing issue, and there is a boundary between what is prospecting and when it becomes mining. So that's a good one. I don't know how much more we can do to clear that up, but there might be some. There are some definitions that are in the rules that we could look at. Like there's a definition for development, it's in the act. It's in the act or the rules.
That was part of the complication of that one is we were working with statutory definitions, which we're stuck with.
No, but
trying to then come up
you could
with.
ask somebody to amend that if it wasn't, we're not using a burrow and a pick anymore. There's a little difference with the expertise that we have in doing things. And certainly if it's better for environmentally, we ought to do that.
Yeah, so that's a good example of where we might be able to find some clarification. We have to look at the act and find out what those definitions are. And then if I recall, the act didn't have a definition for development, but the rules did, and so that causes a little bit of confusion. Because then there's that prospecting, and then there's development, and then we're really talking about mining. And so, but development is part of the mining, really. So it's
Still have to give these people an opportunity to find out there's a product there worth mining.
right, and that's the prospecting side of things. And so there's always that boundary, and we've kind of pulled it back a little bit to be where we think it looks like mining. We're calling out mining permits. Now, of course, people can always appeal every decision we make at staff level to the board, and that's kind of what happened in that instance there. Had something else that was, in relation to Wendy Kern was the lady who came before the board, upset about a variety of things, but she contacted me later on and was asking, about making changes to a variety of rules. And I indicated to her at that time that I would bring this before the board and we'd have that discussion. But, and some of those, I made it clear that if it's in the rule, we have some latitude there. If it's in the statute, we can't really do anything with what's in the statute unless you want to carry that over there to the legislature and have them change it. And so can be a perilous journey. So,
No.
So, yeah, experience speaks.
I was going to ask about that, actually. Do we have adequate statutory authority to deal with custom mills? And to me, milling is milling, but I understand that there's an issue when a mill may not really have a mine permit, or they don't need a mine permit, they just need a permit to mill. And so are they adequately covered under the statute?
Presently our mills adequately covered under the statute? Is that what your question? Custom mills? Well, that's the problem we're having a little bit. I think the definition of mining does include various other activities and processing and screening and this and that, and milling is included in that definition, if I recall. So then it goes back to the rules, and there's this rule about a custom mill, which isn't really in statute. And that's where this history between hazardous waste and our division comes into play. And it's just, it really causes us a lot of problems. We've had probably 3 or 4 different instances of folks just wanting to fire up mills, and they've been doing it. They start grinding rock and they start separating it out, and then pretty soon you have a waste product you're dealing with, and sometimes that waste product can be acid or toxic forming or hazardous materials, and so we have to deal with that. We work with hazardous waste management on that. Sometimes they're like, well, we don't think it's a custom mill, or we think it's whatever, and it's so people are slithering around a little bit, honestly, through the regulations. And then what it does is it throws it back to the county, and the county decides they want to start regulating things. That creates a problem for us. And this actually happened back in 2008. Things kind of slowed down for a little while, but for some reason it's kind of ramping up again. Maybe the price of gold's up just a little or something. But in 2008, we brought an item before the board. At that time, the board did determine that this should have been a captive mill and regulated under our regulations, and that determination was made. And what they were doing is they had kind of a portable setup of sorts, and they were going into old tailings dumps up here in Clear Creek County and reprocessing that. Well, a lot of those tailings dumps, the processing wasn't very efficient back in the day, so there is quite a bit of gold left in there. People have been wanting to do this for a long time. But the act of redisturbing those dumps and dealing with the waste gave us a lot of pause. And so We did have a little wrangle here before the board, and the board did rule in our favor on that instance, and pretty much has since. Scott might be able to address, we're working on updating our MOU with hazardous waste management, and we're trying to get more clarity, particularly in this custom mill area. So, do you want to?
Sure. I would take it even a step farther and say that the term custom mill is a regulatory fiction, and that it contradicts what the statute says. You have the definition of mining operation. Mining operation also includes the following operations on affected lands, which is milling. So I think that the kicking it over to CDPHE and having this definition of custom mill in the regs actually we don't have, there's no jurisdiction to do that. The statute says that DRMS is the one that regulates milling. And we are working on updating our MOU with CDPHE and Hazardous Waste Division regarding those specific definitions. And I think that will provide some clarity. But I also think that removing the term in the mineral rules will further clarify that milling is solely in the jurisdiction of DRMS. There's some consultation that will go on with CDPHE, of course, but it's really, I don't know the exact history behind it. I've read a lot about it, but I think it's a regulatory fiction, and that's something that you statutorily cannot provide jurisdiction to anyone else.
What's milling?
Milling is further processing of the ore to extract the target
You're
mineral.
using the term ore. Is that specific?
Well, I don't think it's defined right now. So, but I would say that's what it is.
So if it isn't ore and they're processing it, is it milling?
Give me an example.
Somebody hauling gravel to an off-site gravel plant.
Oh, I see. Well, we're talking about hard rock here, so.
Oh, okay, I don't care.
So what we are talking about is the further refinement of that ore to extract that specific metal out.
So in effect,
it isn't
if
just,
you're hauling an ore from one place to another and milling it, you're automatically defining that as affected land.
the mill would be, yes. So what's going on right now is this custom mill is typically, if the mill is right next to the mine, it's usually the same operator, same company conducting all these activities. What's happening now is maybe the ore is being mined somewhere and then they're hauling it out. Who knows? It could be 100 miles away and doing all the processing out there. And then because of the way it's the definition of custom mill is in our rules, it just provides a lot of opportunity for shenanigans, frankly, to say who owns and who controls and who's this and who's that. And, they'll do that even though they really are all in cahoots together. They'll separate it out so that we're not regulating the milling side of it. And hazardous waste, here's another issue that's going on with this. Hazardous waste management deals with waste management. So they're not very concerned about the milling process or the upfront process where somebody's bringing ore that's probably acid forming, stockpiling it, and then grinding it and doing all the processing to extract the metal, and then dealing with the waste product. When you get to the waste product, that's where hazardous waste was picking up the ball. So it was leaving that in-between part, the milling. The mining we had covered for sure, is that the milling before the waste disposal was left uncovered. And that's where the county was jumping in 8 years ago, wanting to write some regulations. And the regulations were completely overlapping with our regulations. So it was creating quite an issue there.
Is that what Cotter was doing at Canyon City?
Canyon City, so uranium mills are regulated clearly. This is defined under the Radiation Control Division. So uranium is its own special category. So a uranium mill must have a license, a radioactive materials license from the Radiation Control Division.
This is wild, but CF&I used to haul iron ore into the mill and then process it. Would that then say that steel mill would come under us?
I don't know. I'll reserve comment until I think about that one a little bit. I don't think they're going to be doing that anymore, are they?
They're not doing it now.
No, I
that's for
know.
sure. Well, I have concern that we're expanding our workload into an area we don't necessarily have authority. But as long as you define it as or, I guess, that's pretty clear.
We are regulating mills. For instance, we're regulating the mill. Cripple Creek and Victor has a mill. Henderson has a mill. Climax has a mill. There's a mine west of Boulder. They have a mill. Those are regulated under us because they're right there next to it. So then if you try and separate it out.
Are you saying you're controlling the output or just the hazardous waste, just the?
Well, we're ensuring that the tailing is handled in an appropriate manner so that it can be stockpiled or however they're going to deal with it. Sometimes they're dry stacking now. Sometimes they put it out in these slurry ponds. But we'll have geotechnical stability on that. We'll have a reclamation plan to cap it, probably prevent water entering into it. We'll have groundwater monitoring to ensure that there's not something seeping off site. A lot of the mill tailings are, pretty inert, but not all of them are. And so some of them still contain metals. Depends on the target that they're shooting for. So we have regulated a lot of mills in the past, and then there's these other ones that are kind of out there where they're going, oh no, we're custom mills and don't regulate us, but really the same practices apply, whether it's captive or custom. But then with the health department saying, well, we're not really dealing with that milling process, and that's where hazardous materials are handled, are used a lot of times when they're using acid, a lot of reagents potentially in that milling process. Certainly at Climax with the molybdenum extraction, they use some pretty nasty chemicals in that process. So, if it's a DMO, we're having containment, we're having spill prevention, that sort of thing. These custom mills operating off on their own, we're not sure what they're doing.
Well, in that instance, would a custom mill be a DMO?
Yes, they would. In all likelihood, yes. That's how we've permitted it to date, and it seems to make sense that would be what they would.
So we've had one in eastern Colorado that applied and has kind of gone away, and I imagine it's coming back.
We have two in eastern Colorado. One of them was their where was that, north of Manzanola or somewhere off out in
Sugar
there.
City.
Well, there's one in Sugar City too. There's another one that we have. We have two sites down there. One of them we permitted. The one in Sugar City, we brought them before the board and they agreed to get a permit. Now I don't know what they're doing exactly.
So that site would be a DMO.
Yes, it would.
And the one in Manzanola is a DMO.
It is. The Precious Mine, it's called, in Manzanola, I think. I think it's north of Manzanola. I think it's in between, where would that be? Manzanola and Rocky Ford or Fowler. Well,
Ford West, east and Fowler West, but yeah, I don't know.
So I think it's in between Rocky Ford and Manzanola.
So in effect, what we're saying is anybody who's processing ore, regardless of whether it's on the mine or someplace else, we're going to regulate it so far as process and what's left over.
Yes. We think there's a little crack in the regulations right now that people can slip through. And then sometimes they create really problematic environmental concerns when they just disappear. So leaving barrels of hydrochloric acid, sulfuric acid around. The proposed mill down in Sugar City is, they were using a process where it's acid digestion of the mineral and then extraction of the metal out of that effluent. So it's a pretty gnarly process. So I think for the state, we want somebody to be overseeing activities like that and not leaving messes around. So that's just one area on the, but it's kind of maybe the catalyst for wanting to do a rule change on the Hard Rock side. As I said, there's a little bit of cleanup I think that can be done in the prospecting. Just a little more clarification there. I think when you're making rules, sometimes until you put them in practice, you don't realize where there are shortcomings. And then when you're dealing with them, you're wishing that you could have that extra step sometimes. And then, like I said, cleaning up that release process with DMOs is, it's not a bad process. It's just it's badly explained, I guess. We need to have the intent of what's there. We just need to have it in the appropriate location and have more clarification about how that proceeds. On the construction side, I think the signage is something that probably, I should be dealt with a little bit. It makes sense to me. And, I think it will do nothing but help us. But the people find out about stuff anyway. I mean, they're finding out about it through the notices and the signage. But, it's all out front anyway. It just needs to be a little more clear, perhaps. The actual signs and maybe Tom, you have a disagreement with this, but the signs at the site, I think, could be a little more clear about who you contact if you have a problem. Right now, our rules say something like you have to have a sign that says a permit has been issued by the Mineland Reclamation Board, has to have the permit number and maybe the mine name. I can't even remember if that's it, but not a phone number or contact information or anything like that. So I think that would be appropriate to be able to let somebody know who they can call if they see a problem out there. They figure it out usually, but
Well, if the permit number's there, they can go on the site and find the current designated person. The problem is if you put phone numbers on there and then change phone numbers or change people, then you got to change the sign.
Yeah.
No big deal.
Technical revision.
Yeah, that's right.
So those are some of the things that, is there you guys have anything else that you want to talk about just today in general, just loosely before we, maybe go away and start thinking about this a little bit more? Are you on board with this idea, or, I guess just trying to gauge how you feel about it and whether we can begin proceedings and start making plans. It won't happen for the next couple of months, like I said, but it'll be, June or July, I think, at the earliest.
I think it's a great idea to clean up the rules and make them clear where they can be, and also consistent with the statute is also very good. So I don't have anything on the top of my head right now other than the things you mentioned, but I will think about it and let somebody know if I think of something.
I'm sure as you go through the existing rules, things are going to pop out that you hadn't thought about, and suddenly you say, boy, this does apply. I have just a question. The issue that was brought just before this by the opponents, the objectors of the application. Is
the
that
gravel pit?
the coal?
Oh, okay, the coal one, okay.
Whole issue. Is that something that would be clarified within the rules, or is that a statute thing that is just hands off and it's what it is, and whether it's an informal hearing or it's a?
Well,
I was kind of interested.
that was a little confusing because, we have the Hard Rock or the Mineland Reclamation Act was the original Hard Rock Act and construction. Then that was bifurcated. We have the Hard Rock and Construction Material Act. The Coal Act was also passed in 1977, and they have their own regulations and their own set of way of dealing with things. In fact, they deal with all their violations at the staff level. Now they have hearing officers assigned and this sort of thing. They really come before the board. You're more of an appellate board for them. versus us, you actually make the decision on whether there's a violation that we're going to take or whether an application is approved over objections and that sort of thing. So it's really on appeal that Cole is typically here. And that's really what's happened today, is that a technical revision was approved. They objected to it. It's just the rules aren't quite as clear as ours, or they didn't contemplate the process, or I guess, for a technical revision. You know, they have minor revisions, technical revisions, permit revisions, permit amendments. They have a lot more process than the application process itself. So I think in the application process, the amendment process, there's probably more clarification about how those things appear before the board. I used to work in Cole, but I've forgotten all those rules about how it works. But so you're not typically seeing Cole items before this board very often, whereas the minerals items have to be here because the board is the one who has to take the action on the violations and on approval over objections.
Can I tag on that? If I can just tag on that. And the issue with the pre-hearing conference with respect to the Cole rules, again, as Mr. Stark said, that is a federally delegated program, so fundamentally different from the minerals program in that respect, which is a state program. So our minerals program in the state is very different from minerals programs in other states, whereas our coal program is the same as all other states because it's federally delegated. The Office of Surface Mining fashions the rules, and our rules mirror theirs.
I'm going to ask a question. You may say we can't answer that. Did they come over to us then? Because this was an avenue that they could squeak through or present something that they'd already had results when they went before the mining board, right? And they didn't like those results, and so they kind of come over to us now.
Well,
And
it's
I'm
maybe,
just wondering, I'm still confused. Why are they dealing with us at all?
well, maybe Scott can explain that.
They haven't gone in front of OSM. The issue would be before you. I think it's very atypical for a TR to be this cumbersome and litigious, and I don't envision this happening very much in the future. But there is no provision for them to go in front of the federal board or OSM or anything. It comes before you.
It does.
Yeah.
Okay.
It's just that most things are dealt with at staff level in the Cole program because the rules are a lot more prescriptive than our rules, and they follow those federal rules. So they've worked out a lot of this process. But if there becomes a dispute, that becomes the board, the mine land board acts as an appellate board in that program board. You're actually involved in our decisions on the mineral side.
I guess I agree with Jill on that. Yeah, by all means, try to clean those up where you can, and where you feel like you need to revise a few things. Making sure that it's consistent with the act.
Will you ask CMA and CSSGA if they have proposed changes?
Right. So I think what would happen is the board authorizes us to begin the rulemaking. We go through and do the red line initially, and then we put that out for comment. And yes, if they have changes they would like, that would be the opportunity at that time to add that in there. Then at some point, this is brought back before the board to say, you know, here, I don't know if we're going to bring the red line first and then we go out for those meetings or how that works exactly. But at some point, they will have an opportunity in an informal stakeholder group meeting to say, you know, we'd like this rule to be changed, or we've never liked this, or we need to add that, or whatever. So yes, there will be an opportunity for them to fashion the changes along with us. So, and then at some point, we hopefully have some pretty good agreement. We'll be bringing it back for the final approval, and the board has to be the one to approve the final rulemaking. And there'll be a hearing, a formal public hearing, at which that would occur. And if there's some kind of disagreements, then that's where that all comes out. And as Jeff alluded to during the uranium rulemaking rules, there's a lot of disagreement about both sides. So I think the board landed well in the middle on that. So hearing all the testimony and made a few modest changes at the end. And, you know, not everybody is satisfied at the end, but we want workable rules. So and that's ultimately your job in the end is to make sure these aren't going to be confusing and unworkable for everybody involved.
Did you say, or is that clarification of development was it uranium that we had a couple of issues where on those
Underground borehole mine.
no, the ones where I can't remember the term, where when you're inactive.
Oh, temporary cessation.
We had those temporary cessation things on some uranium deals, and the objectors were making the point that by doing planning for reclamation, that's part of development, and so they were actually, their period had started and all of that. Isn't that where we got a lot into the definition of what development is?
Yes, that did come up during those temporary cessation hearings.
I just wondered about a little discussion earlier about definition of development. Are you saying that that's something we can look at here?
I think so. Now we have to look at the act and find out if that definition of development is in the act or if it's in the rules. I think the rule about temporary cessation, I can't remember what the rule or in the act, I can't remember what it's titled, but it's life of mine, I think, is the rule it's under. It talks about what life of mine means, and that's kind of where all this temporary cessation emanates from. And development is included in there. Is like, are they in development or are they mining? And you know, the act talks about mining. It doesn't talk about development of mining, but you know, take the Henderson mine, for example. I think it opened in 1976, but I think prior to that, they were driving a tunnel, a 9-mile long tunnel from Clear Creek over to Grand County to, you know, because they're transporting all the ore over to the mill in Grand County. So there was a lot of development that was probably occurring. It's really kind of mining, you know, sinking those shafts. There's a lot of development waste. So yeah, that's a good one to bring up and maybe get a little clarification on, perhaps. I've often thought it would be nice to have one permit number assigned for a mine. Like this would be the normal way things would potentially happen, is you'd get a notice of intent to conduct prospecting. That would then you do a changeover to a development permit, and then that same permit number would become your mining permit in the end, and you would have, so you'd end up with the same permit number. Administratively, it would help with tracking. A lot of the notices of intent, though, don't end up with any kind of development at all. As you're probably aware, you know, they go out and drill holes, and they just don't find what they're looking for, or there's not enough ore there, or whatever it is, and or they just, you know, the price of silver goes up, and they get excited and they start drilling holes, and then before they can move into the development stage, the price of silver goes down, so there it sits. So yeah, I mean, I think development would be something we might take a look at, and I can't remember if it's in construct. Is it in the
Development's it's a statutory definition, so that's part of the struggle. And as you know from the hearings, it's one of the more complicated areas, is that project development, mining operation, kind of the blurred lines between the three. So our hands are somewhat tied by the statutory definition, but as it relates to cessation, you know, we've had discussions of cleaning up that rule because it is, you know, difficult to implement. We'd like to get something that's easier to implement and remain consistent. So to the extent development overlaps with that, I think we can clean that up. But yeah, we're a bit tied to the statutory definition.
Anything else? Do we need executive session?
Jeff and I have some updates
Boss.
on cases. Yes. I do.
Is this the right motion?
Yes, it is.
I move that the board enter into executive session for the purpose of discussing with counsel disputes that are the subject of pending or imminent court action, discussing specific claims or grievances, receiving legal advice on specific legal questions, and discussing matters required to be kept No more to come before the board. We're adjourned.